The automatic stay, the most powerful tool in bankruptcy law. Section 1. The hook and the instant emergency injunction. Imagine a legal tool so staggeringly powerful that it can instantly halt a foreclosure sheriff sale on the courthouse steps just minutes before the auctioneer drops the gavel. Imagine an injection of federal authority so immediate that it can stop a repossession truck in its tracks while it's actively backing down your driveway, immediately force an electric company to turn your power back on, and instantly unfreeze a bank account that a creditor has locked down. This is not theoretical. It is one of the fastest legal protections in the entire U.S. system, and it activates without waiting for anyone's permission or approval. In the entire American legal system, there are very few mechanisms that operate with this level of immediate, absolute velocity. It does not require a week of judicial review, it doesn't require a special hearing, and it doesn't care if your creditors agree to it or not. It is called the automatic stay, and it is the single most powerful shield available to consumer debtors in the United States. Hi, I'm Sean Quinlan, a bankruptcy specialist right here in Pennsylvania. Today, we are conducting a deep dive masterclass into the mechanics of Title 11 of the United States Code, Section 362. We are going to look at exactly how the automatic stay works, explore the extreme legal protections it deploys over your family, the exact microsecond you file, and show you how we use this federal hammer to punish aggressive creditors who dare to violate its terms. Once it is triggered, everything changes instantly for the debtor, and creditors are legally forced to stop all collection activity immediately. When you are drowning in debt, you feel like you are constantly running a marathon with no finish line. The phone calls, the letters, the court dates, and the threats create a state of perpetual fight-or-flight response. It is the legal pause button that stops financial chaos in real time, and it gives you the breathing room needed to rebuild your financial life. Section 2. The microsecond trigger. How the injunction descends. Let's talk about the trigger mechanism. The automatic stay is governed by Section 362 of the Federal Bankruptcy Code. The word automatic is the most critical part of the statute. There is no delay, no waiting period, and no approval process once filing occurs. The protection begins the moment the case is officially submitted. In a standard civil lawsuit, if you want a judge to issue an injunction to stop someone from hurting you, your attorney has to write a long brief, schedule a formal hearing, present evidence, and convince the judge to sign an order. This process takes weeks and costs thousands of dollars. But the Bankruptcy Code operates on an entirely different level of urgency. The exact microsecond your bankruptcy attorney clicks the digital Submit button on your Chapter 7 or Chapter 13 petition to the Federal Electronic Case Filing System, a formal case number is generated, and the automatic stay instantly descends upon your life. It is a self-executing statutory injunction. It requires no judicial signature and no prior evaluation. It is an immediate, absolute command issued by the federal government of the United States. At that moment, federal law takes control of your financial situation, and every active collection action is legally forced to freeze. The moment that case number is stamped, a massive legal wall surrounds your entire life. By explicit federal mandate, all collection actions of every single variety must instantly freeze in place. Nothing in the collection process is allowed to continue once the stay is active. The law overrides every individual creditor action simultaneously. Section 3. The absolute scope. What the stay halts instantly. The scope of the automatic stay is all-encompassing. Let's break down exactly what it freezes the moment we click File. First, all collection harassment. The phone calls must stop instantly. The automated dialers must be deactivated. The collection letters, emails, and text messages are legally barred. If a collector has been calling you 5 times a day, they are prohibited from making a single additional attempt. Second, all active civil lawsuits. If a credit card company or a collection agency has filed a breach of contract lawsuit against you in a Pennsylvania Court of Common Pleas or before a magisterial district judge, that lawsuit is instantly frozen in time. The court dates are canceled. The judge cannot enter a judgment against you, and the creditor cannot move forward a single inch. Third, all foreclosures and sheriff sales. If your home has been scheduled for a sheriff sale by your mortgage lender, and that sale is set to occur tomorrow morning at 10 a.m., Filing a bankruptcy at 9:59 a.m. cancels that sale by operation of federal law. The county sheriff is legally forbidden from auctioning your home. If they do it anyway, the sale is completely void. Fourth, all bank account levies and wage garnishments. If a high-priority creditor has issued an active attachment on your bank account or a garnishment on your income for taxes or student loans, the stay commands them to release that attachment immediately. Your income is restored to your control. This protection is broad enough to stop nearly every major collection action at once. It is designed to prevent financial collapse while your case is being handled. Section 4. Enforcing the hammer. Penalties for creditor willful violations. Now, you might be wondering, what if a creditor pretends they didn't get the message? What if an aggressive debt collector chooses to ignore this federal stay and continues to call my phone, send me letters, or harass me at work? This is where the fun begins for your attorney and where it becomes incredibly expensive for your creditors. Under Title 11 U.S.C. Section 362(k), the law provides a severe enforcement mechanism. Any individual or corporation that willfully violates the automatic stay is liable to the debtor for actual damages, including all of your attorney's fees, and in appropriate circumstances, the court can award massive punitive damages. Violating the automatic stay is not a small mistake. It is a federal offense in bankruptcy court, and courts take these violations extremely seriously. Let me explain what a willful violation means under the law. It does not mean the creditor intended to break the law. It simply means they had knowledge of your bankruptcy filing and they chose to take a collection action anyway. Once we notify a creditor of your case number, whether via formal court mail, an email, or a phone call from our office, they are on the clock. Once the stay is violated, the consequences shift heavily against the creditor. The law is designed to protect debtors and punish unlawful collection behavior. Section 5. Summary and call to action. If you are living your life under constant financial fire, you do not have to endure the barrage alone. You can deploy the single most powerful legal shield in the country to get the immediate, absolute breathing room you need to fix your life. You do not have to face creditors while unprotected. The law provides immediate relief the moment you file. If you are facing an impending sheriff's sale on your home, a repossession threat on your car, a frozen bank account, or an active civil lawsuit right here in Pennsylvania, time is your absolute enemy. Let's deploy the automatic stay to protect your family today. Click the link below in the description box to schedule a completely free, 100% confidential emergency strategy session with our firm. We will review your files, explain your options, and hit the pause button on your creditors once and for all. Acting quickly can change the entire outcome of your case. Delay only gives creditors more time to move against you. If this video showed you how powerful the law can be, please give it a thumbs up, subscribe to our channel, and drop a comment below. Stay strong, and I'll see you in the next video.